So we talked about, we've gone into planning pretty in depth here, and obviously we can design these complex plans, whether it's an estate plan or Medicaid planning, oftentimes require us taking steps to be carried out over a period of many years, especially with Medicaid planning, where it might be a 5-year plan to accomplish it. And I think one of the most overlooked documents in an estate plan is a power of attorney. I mean, you'll hear someone say, "Oh, I don't need a power of attorney. I found one on the internet."
Yes.
and
people come into my office all the time and they say, "Oh, I already have one," and I say, "Hand it over. Let me see it." And it's they got it at Office Max. So.
Yeah, or it's a power of attorney drafted by a general practitioner attorney. And they got it on the internet.
Exactly. Yes. They don't do that a lot. So they Google it. Yeah.
And so, but this is an incredibly crucial document. Many people eventually become mentally incapacitated, and some of this planning and many of these decisions that a person makes in their life that's in this situation are actually going to be made by a third party. It's going to be made by who they designate as their power of attorney. And just thinking, as you were going through that before I was picturing sort of this typical client that walks in your office, and I'm imagining a person who comes in and says, I'm 70 years old, I just got diagnosed with Alzheimer's. So it's like, well, this person might very well have 5 or 10 years before they get to the level where they even need this planning or they need long-term care. But then somewhere along the way, they might not be able to make their own financial decisions. And so I just wonder if you could talk a little bit about power of attorneys and what are the important considerations there?
Yeah, absolutely. Without question. Anyone who is kind of marching towards their later years, like we all are, one of the most important documents for them to have is a general durable power of attorney. You have your healthcare power of attorney and you have a financial or general durable power of attorney. Both are important, but in many ways, the most important one is the financial one. And that is because the end result, in an elder law office, we always use the example of the stroke because that's the catastrophic thing that happens when you don't expect it. And then you're shot. If it's a massive stroke, and say from that point forward, if the person is unable to speak, is unable to understand, if they don't have something like a general durable power of attorney in place, it means that no one is going to have the authority automatically to get into their bank accounts, to handle legal decisions on their behalf, make decisions for them, sign contracts for them, pay their bills, you name it. The only way that their loved ones can gain the legal authority to do that is they're going to have to go to court and be appointed as the person's legal guardian or conservator. Okay, so a judge is going to be involved. There's going to be a guardian ad litem or a lawyer who's been appointed by the court to represent your loved one. You, as the adult child or the spouse, may or may not get named as the guardian. So again, control. You've totally lost control of that situation. And it's costly. It can cost thousands of dollars to go through a guardianship proceeding. So instead, what I will say to people now, while you know what you want, while you know who the players are in your life, let's talk about if you needed help someday, if you were unable to make your own decisions, who do you trust to do this for you? Who is going to step in and take care of you? Usually it's a spouse if they're both pretty well and independent. And then we'll name a backup, which is often an adult child. That's the most common thing. Sometimes it's multiple adult children. Sometimes they're named in order. Sometimes they're powers of attorney, co-agents under the power of attorney. And then another key thing, and people bring this up all the time, there are kind of two flavors to your general durable power of attorney. There is one that is just a general durable power of attorney that goes into effect immediately. And then you have something called a springing power of attorney. I will oftentimes have people in my office that say, listen, I am taking care of myself. I'm fiercely independent. I don't want my child interfering until I have lost it completely. And only if I have like dementia do I want my kids stepping in and doing this. And, can't that be written into the power of attorney? And I say, yes, we can make it a springing power of attorney. And they say, great, that's what I want. And I say, wait a second, let me explain. The point that I try to make to them is, once we've made it a springing power of attorney, it means that the person can't use it until they've brought in outside medical opinions. The child has had to jump through all these hoops to have mom or dad declared incapacitated. And there could be delays. Maybe mom or dad has dementia now, doesn't want to go to the doctor anymore. It can be a real pain in the neck to do this. And what I say to them is, if you don't trust your child now, immediately today, to manage your money for you, why are you going to trust them when you've got dementia 10 years from now, when you have no idea what's going on? Because you should only be naming someone in that role who you're ready to hand the keys over to, someone who is not going to steal for you, is not going to abuse that authority. So it becomes really, really important to pick the right person to be in this role. And once I don't think I've ever had anyone, after I've kind of laid it out to them that way, I don't think I've ever had anyone opt for a stringing power of attorney. What's more difficult is when the person just doesn't have, maybe they're not married, they don't have children, and they don't have anyone involved in their life who can take on that role. That's a trickier situation, but it's very case by case.